Good afternoon, everybody. Welcome to Consumer Trial Lawyer Academy. Today we're going to be talking about marshaling evidence. When we talk about marshaling evidence, what is it that we are exactly discussing? So, marshaling evidence is the process by which you take all the evidence that you have gathered during the course of the case through depositions, documents, etc., and you lay out your evidence in the order that you want to present that evidence at trial. And, let's begin with the idea that a little bit of organization and forethought will help you with this process. In a perfect world, you will have done a lot of this as you've gone through the discovery process. If you're really on top of your game, you'll be clipping your depositions as soon as you get them in. You'll be organizing those depositions and the testimony of your witnesses as you receive them. If you've got great help, paralegals or associates, they're already trained to jump on that and do it. They already know what's important, and they're ready to dive in and grab it and go through that as part of reviewing the deposition after the trial's taken place. So, marshaling evidence, you're basically starting with what's the first thing I've got to present to the jury, and you're going all the way through to the end. This includes everything from the actual physical evidence to the order in which you're going to present testimony live at trial. And it also includes, clipping depositions that you're going to play in part at trial rather than have, a person live. So we're talking about consumer cases. I've been trying a lot of mortgage servicing cases in front of juries. And so we'll take it from that perspective first. In a consumer law case, you typically have, in the best cases, the generic setup of asshole corporate defendant versus, average consumer. And you're almost always talking about conduct that, a jury panel will find outrageous. A lot of things happening that they will not understand because most people just don't understand how, corporate America could be so callous and indifferent and motivated only by how much they can steal from the normal person. And so, the way to try these cases to get the right outcomes is to focus the trial on the defendant's conduct rather than on your client. And so the way to try that is, when you're marshaling your evidence, you want to think about it this way. I want to get the corporate defendant on the stand first, and I want to get all the relevant documents in, all the relevant testimony about their conduct. Okay? And so when we think about marshaling evidence, we're thinking about the key components of the case, the key documents that deal with the corporate wrongdoing. And we want to think about putting that in a logical, chronological sequence unless there's some reason to leave that order, but generally don't. When you're telling the story through the corporate defendant and through their actions, again, tell the story chronologically in a linear timeline and make sure you take them from the beginning to the end. And so as you're thinking about your planning, you're going to want to focus on generally the 30B6 testimony that you've taken, the key corporate docs, and the key corporate communications. Typically, you'll be starting off with the corporate 30B6 as the trial witness, although occasionally facts will merit a situation where you may have employees of the defendant who are at trial and are on the stand first. Now, the way these trials work, if you've done your job, when you get through presenting evidence, there typically won't be anything left for the defendants to do. In other words, it'll look to the jury as if they don't have any witnesses to call their own. Most of them will call back their corporate representative, and they will still try to give a guided story of the wrongdoing from their perspective and try to explain it away under a coached story that they've decided to tell to the jury. But, you know, that should reek of inauthenticity if you've done your job correctly. It should be very apparent that this is a coached and contrived story designed to excuse away the misconduct. So, marshaling evidence, if you're starting from scratch, you just have a giant bunch of boxes or computer files full of documents, you know, you have to begin with what's going to be exhibit number 1. And you got to go to exhibit number whatever to get yourself to a point that you have all of your evidence in. You know, it's not uncommon in a mortgage servicing case to have 100 plaintiff's exhibits. You may have 100 defendants' exhibits when they get through with their portion of the work. But for your trial, you want to have every document marked that you expect to use to prove your case in chief, to prove the corporate misconduct, to prove notice and knowledge, and, you know, to rebut any arguments that they may contrive about, you know, how this could have been an innocent or honest situation and not just, you know, general corporate fuckery that's just designed to screw people. And so once you have, you know, gone through your list of documents and you have obtained what you think is your list of exhibits, you know, you should start with the way to get that in organized fashion is you start with what are the documents I have to have for the corporate defendant. And then you look at, okay, once I go from the corporate defendant, are there other corporate witnesses I'm going to call? And if there are, then you need whatever documents you need to use in that testimony. And if they're already included in the first batch for the corporate defendant, then that's great. But you're looking for new documents, things that you don't already have that you need for a particular witness. And that's the only way to check it down as you go through the list and to be thorough. And then once you're past your corporate witnesses, then the next thing you're looking for is in your order of proof, are there experts? If there are experts, then you need to make sure you have all your expert documents in line and you know exactly what the defendants are relying on, and you have whatever materials you've pulled to attack the defendant experts and to support your own experts, all properly documented. And then you got to have any medical people. You got to have your medical records. That also includes mental health professionals or counselors, therapists, things of that nature. And then you've got to have your own client's documents for anything in particular that isn't already included in the documents you've already marked. So that's typically going to be things like email communications, letters that they wrote, things of that nature. And once you have those things in place, then you also have to think about the other categories of witnesses that you may have, what I call friends and family witnesses, which we will discuss more in a separate video. And if there are any separate documents for them, you would also want that information as well. Once you have gone through, essentially you have created this map, right? You have, on the one hand, the list of witnesses from corporate defendant or corporate fact witness, whichever one's first, all the way through to the very last witness that you're going to have in the trial. and you know that you have checked the box of every exhibit that you need for each of those witnesses. And, you know, once you have that box checked and you know you've gone through it, then you have, quote unquote, marshaled your evidence, in the sense that you have every document that you need to examine every witness who will testify. You have every document that you can foresee that you will use for rebuttal or impeachment of any witness that's going to testify. And you will have all the documentary and physical evidence that you need to meet the elements of your case. And if you have done all that, you should end the marshaling of evidence process with the order in which your witnesses will appear from first to last, and the order in which you anticipate using your documents from first to last. And that's particularly helpful because it requires you to stop and think about this order of presentation of evidence that's so critical to these cases. Because one of the rules we talk about when we talk about trial psychology is the rule of primacy. When we're talking about a case of this nature, what we want the primary focus to be, what we want to have primacy, is the corporate wrongdoing. The best cases always show a pattern of conduct that would affect any consumer who dealt with this corporate defendant, and your client is just the victim who brought this case. Anyone else who ever dealt with this defendant in this scenario could have experienced the same misconduct. And so the focus is to prove the extent of wrongdoing, prove the corporation's notice and knowledge of the problem, prove that they engaged in actively or accepted the conduct of the employees and agents such that they were benefiting from and accepting the benefits of the wrongdoing. And in that instance, then, you've eliminated the ability to argue that, oh, these were rogue actors, when you have this notice and knowledge brought in as part of your evidentiary materials. So when you have completed the marshaling process, you have essentially laid out your trial. And this will help you as you get into, the actual steps that you are engaged in, so that you have the right plan to execute the trial. And again, depending on how much work you do along the way, depending on how much thought you're giving to where you're going to be with your evidence, you may have already gotten deep into that process. One of the best things to do to help yourself is to start with the jury charge of what the elements of your case are, and that becomes, answer for yourself. If the judge asks me tomorrow, what evidence do I have to prove each of these elements? What am I going to point to? And look for any places where you're weak or have any gaps. And you should be doing that literally from the outset of the case, because if you've done your proper vetting and you've done your proper planning, you've been considering this literally since day one, but you should be able to know that the evidence you have gathered is going to touch on all of the elements of your claim, so there are no holes in your case which can be attacked post-judgment, post-verdict by the defense lawyers who are so excellent at pushing paper and writing briefs but who are not always excellent at recognizing the parameters and contours of the trial experience. And when you're done with this, you know exactly what evidence you should be putting in, exactly what witness you're using to put it in, exactly what order it will appear. And if you've done it correctly, when you get to the pretrial hearing in federal court several weeks before the actual start of the trial, you should be able to tell the judge and your opponent, these are the people I'm calling, this is the order I'm calling them in, and we've got our exhibits marked 1 through whatever, 100, and you're going to see those pretty much in order, barring something unforeseen. And, if your trial preparation has been sufficient and efficient and accurate, then, when you get to the end of the trial, you should be able to look and see that you called the witnesses in the order you expected, barring some unforeseen scheduling problem, and you went through the exhibits in the order that you expected. Again, barring something like a doctor having to be taken out of order or something, which does happen. But, if the trial runs smoothly, you would have gone in perfect order and gotten to the end, and you would have been able to check all those boxes and know that you had put everything in evidence that you needed to win, which is the ultimate goal of this process and this exercise, is to know that when you walk into the courtroom, computer in hand, trial tech person in hand, in tow, big banker's box full of documents, whatever it is you're doing, you have everything you need to win. And you know that if you check off all those boxes and you get all those documents in, you get all that testimony in, you've proven your case and you should win. So that process, again, you're in the intensity of preparing for trial, which means that your life should consist of whatever sleep you have to survive, whatever limited amount of food you need to stay healthy, and the rest of your life totally committed to examining every piece of paper and every document and every bit of testimony in your case with the intensity of trial preparation, looking for all the ways that this evidence can be used and argued during the trial, and making sure that you've covered all your bases. And, for me, again, that is a never-ending process, essentially from the time that we designate our documents and designate our witnesses all the way through the time that we end up with a verdict. We're constantly examining everything we have for, a new intuition, a new insight into how a particular document or a particular statement can be argued and presented in a more effective way all the way through trial. So, not uncommon that we begin this process as part of getting our pretrial materials together. By the time we're at the pretrial hearing, we know the order we're going in, and then from there, it becomes a matter of perfecting that material as we're preparing to actually execute the trial. And that gets into the next video, where we talk about, the work we do pre-trial to order our presentation and make sure we have what we need. So we will cover, we'll start to get into the next video, sort of the elements of the trial in that context. So again, thanks so much for your time. We appreciate you watching the video. If it serves any purpose for you, helps you in any way, please like and subscribe. These things that YouTube says are super important to getting things done. And thanks so much for taking a few minutes to share this time with us. Thanks, and talk soon.